to have a vote on a Supreme Court nominee either up or down during a presidential election year. And I've been here when they have had, in the past, such votes. But Republicans instead cast aside the archives. They swapped the nonpartisan review process used for every nominee since Watergate for a partisan one. And I think you only have to look at Watergate to see why we have that nonpartisan process. It's followed by every nomination since Watergate until today. And my question still recurs: what is being hidden and why? Every White House record that we've received was handpicked by your deputy in the Bush White House. A hyper-conflicted lawyer who also represents a half dozen Trump administration officials who are under investigation by prosecutors in the Russian investigation. And this partisan lawyers decided which of your records the Senate, but more importantly, the American people get to see. Fourth, countless documents that have been provided to the committee contain apparent alterations and omissions with zero explanation. No court in this country, certainly no court that I ever argued cases before, would accept this as a legitimate document production. And the United States Senate shouldn't either. And fifth, more than 40% of the documents we have received, almost 190,000 pages, are considered committee confidential by Chairman Grassley. For the vast majority of them, there's not even a conceivable argument to restrict them. Compare this to the mere 860 documents that were designated committee confidential for Justice Kagan, and that the request was made by the nonpartisan archives, not by this committee. And we still had 99% of our records. And sixth, on Friday, we learned that President Trump is claiming executive privilege over an additional 102,000 pages of your records. Such a blanket assertion of executive privilege is simply unheard of in the history of this country. And the reason it's unheard of is because it is so outrageous. The last time a president attempted to hide a Supreme Court nominee's records by invoking executive privilege was when President Reagan did this for Justice William Rehnquist. But then Republicans and Democrats came together and we demanded the documents be released. And President Reagan said, okay, and they were released. Boy, how times have changed. And seventh to date, we've received less than half of Chairman Grassley's partial records request, meaning we're moving forward even though we've received a fraction of the records. Even Republicans claimed they needed to vet your nomination just a few weeks ago. And then we received an additional 42,000 pages from your record a few hours ago. The notion that anyone here has properly reviewed them or even seen them at all is laughable. It's laughable. It doesn't pass the giggle test. That alone would be reason to postpone during normal times. But nothing about this is normal. All told, only 4% of your White House record has been shared with the public. Only 7% has been made available to this committee. The rest remains hidden from scrutiny. Compare this to the 99% of Justice Kagan's White House record that was available to all Americans. As a result of the bipartisan process I ran within ranking member Jeff Sessions, when Senator Sessions and I requested it, and we got 99%. What is being hidden and why? And if I've not been clear, I will be so now. Today, the Senate is not simply phoning in our vetting obligation. We're discarding it. It's not only shameful, it's a sham. I felt on the day when I took my oath of office the first time, 44 years ago, I was told by both the Republican and Democratic leadership of the Senate, people I highly respected, that the Senate should be and can be the conscience of the nation. I've represented Vermont here for 44 years. I've served with pride here, believing that the Senate can be and should be the conscience of the nation. Today, with this hearing, it is not being the conscience of the nation. And from the bits and pieces of your record we've received, it appears you provided misleading testimony about your involvement in controversial issues at the Bush White House during your previous confirmation hearings. Misleading testimony. I asked you about these concerns last month, and I want to alert you that I will return to those concerns when you are under oath and I'm asking you questions. What I fear is the American people will not know the full truth until your full record is public, and unfortunately, Republicans have done their best to ensure that won't happen. So we begin these hearings with gaping holes spanning multiple years of your career, that deeply influenced by your own words, your thinking as a judge. And any claim that this has been a thorough, transparent process is downright Orwellian. This is the most incomplete, most partisan, least transparent vetting for any Supreme Court nominee I have ever seen. And I've seen more of those than any person serving in the Senate today. So Judge Kavanaugh, this hearing is premature. I hope you use it, though, to answer our questions directly, clearly, and honestly. Because the American people have real concerns about how your confirmation will affect their lives. And I'll conclude with this. The Supreme Court is a guarantor of our liberties in our republic. Few, I would argue, are worthy of taking a seat. Only those with unimpeachable integrity. Only those who believe that truth is more important than party. Only those who are committed to upholding the rights of all Americans, not just those in power. As you know, inscribed in Vermont marble, above the court's entrance are the words, equal justice under law. For the millions of Americans fearful that they're on the verge of losing hard-fought rights, that aspiration has never been more important than it is today. Frankly, as a member of the Supreme Court Bar and as a United States Senator, I feel it's never been more at risk. Thank you.
Before I call on Senator Cornyn, how ridiculous it is to say that we don't have the records that it takes to determine this person qualified to be on the Supreme Court, when all the documents we have add up to more than we have had for the last 5 Supreme Court nominees. How do we make those decisions for those other 5?
Mr. Chairman,
Senator Cornyn.
Mr. Chairman, if I could just respond to that point, because you're not giving the whole picture, sir. 90% of the documents we haven't seen. It's not the number of documents.
And I'll be glad to respond to that. But
we wouldn't hire an intern, sir, with only 90% of their resume.
Senator,
we're putting somebody on the Supreme Court.
Senator Cornyn.
Thank you, Mr. Chairman. Judge Kavanaugh, welcome to you and your family and friends. I'm amazed at the poker faces I've seen on the front row during all of this pandemonium, unlike anything I've seen before in a confirmation hearing. In my view, it's not because your opponents don't know enough about you. It's because they do know all they need to know, apparently, to oppose your nomination. And even before you've had a chance to answer our questions, including their questions, many of them have made up their minds, but the American people have not been introduced to you before. This is an opportunity for all of us to engage in a question and answer format that will hopefully illuminate why it is so important to have judges who actually are tethered to the text of the laws passed by Congress, signed by the President, as well as the Constitution of the United States. The Senate Judiciary Committee undertakes few more important tasks than the one before us today. Last year, the committee considered and advanced the nomination of Justice Neil Gorsuch, who was just one of many outstanding judicial nominees by President Trump. This Congress has proudly confirmed not just Judge Gorsuch, but 26 judges to the appellate courts across the nation. This includes 3 outstanding Texans to the Fifth Circuit Court of Appeals. Historically, the confirmation of judges to our highest courts was somewhat routine. Justice Gorsuch was unanimously confirmed by a simple voice vote to the Court of Appeals. Not one senator voted against Justice Kennedy, who both you and Justice Gorsuch clerked for, and who you will succeed on the court. Not one senator voted against Justice Scalia's confirmation, who you have called a role model and a hero. But that was before judges were viewed as policymakers rather than fair and neutral interpreters of the Constitution and the laws drafted by Congress. Today, as I suggested, is a wonderful opportunity to re-examine the proper role for judges under our Constitution and the difference between legislators and judges. As Justice Gorsuch wrote before he joined the Supreme Court, upholding and enforcing this distinction between legislators and judges was the great project of the late Justice Scalia's career. Justice Scalia would always remind us that legislators may appeal to their own moral convictions and to claims about social utility, but judges instead should strive to apply the law as it is, looking to the text, structure, and history, not to decide cases based on their own moral convictions or the policy consequences. So this hearing is an outstanding way to remind the American people of the proper role of judges under our Constitution. Our Constitution provides for a federal government of limited and delegated powers with a Bill of Rights to further protect our individual liberties. To that end, the framers created 3 co-equal branches, as you know: the legislature to enact laws, the executive to enforce them, and the judicial branch to settle disputes about the meaning of those laws and the Constitution. Of course, the legislature could change the laws, but only an amendment can change the Constitution. For this reason, Alexander Hamilton wrote in the Federalist Papers. Mr. Chairman, can I pause there until the room is cleared out? Thank you. For this reason, Alexander Hamilton wrote in the Federalist Papers that the judiciary will always be the least dangerous branch, because, as he famously wrote, judges would have neither force nor will, but merely judgment. Today, the Judiciary Committee is gathered to consider whether Judge Kavanaugh will honor that limited role for judges under our Constitution, and whether he will properly exercise the modest and humble power of judgment entrusted to him under our Constitution. I'm confident the Senate will find that Judge Kavanaugh will faithfully and fairly interpret the Constitution and the laws of this great nation, and I look forward to him succeeding Justice Kennedy. One reason for that is because I've been acquainted with Judge Kavanaugh for about 18 years, and I can personally attest to his skills as a lawyer. When I was Attorney General of Texas, as the judge will recall, he helped me get ready for a Supreme Court argument. May I proceed, Mr. Chairman?
Yeah.
As I was saying, when I was Attorney General of Texas, I had a chance to argue a couple of cases in front of the United States Supreme Court. One case Judge Kavanaugh helped me prepare for was one involving the question of school prayer at a high school football game at the Santa Fe Independent School District High School. After that, I was pleased to introduce Judge Kavanaugh to the Judiciary Committee when President Bush first nominated him to be a judge on the D.C. Circuit. What I said back then still stands the test of time.